No jab, no entry. That's looking like the rule across much of Australia when pubs, clubs, cinemas and restaurants reopen after COVID lockdowns. But should the same rule apply to a place of worship? Anglican and Catholic archbishops support vaccination, but they say they simply can't turn away the unvaccinated. So how will the law deal with this problem? Sydney University law lecturer Joel Harrison is an expert in religious liberty.
What you have to assess is whether any limitation on somebody's exercise of religion, in this case, the association component, is, for example, rational. Is it necessary? Are there alternatives? Is the balance being right as between the liberty of, say, the group here and what they're trying to do in balance with the public interest, in this case, the public health interest? Those assessments are done, and they would be done in the New South Wales context, I think, still as a matter of political deliberation.
I know this is ultimately a political decision in a sense, but what if the priests or pastors or imams or rabbis were to simply turn a blind eye and not demand proof of vaccination at the door of their place of worship, and this ultimately ended up in court? How do you think that might play out? Would a court be reluctant in pursuing this?
I think it would just play out in the same way you have other conscientious objection cases. You have cases where people chain themselves to trees and chain themselves in the context of mining and so on. And whether that first offending, leads to actual sentencing and these sorts of things, I think the optics would be the fascinating point to what your question's raising here, because the law that potentially is being proposed downstream, and this is all uncertain, of course. We don't know what's going to happen in the context of this roadmap to freedom, so I don't think we should be hasty in making full assessments. But yes, if it's a case of what you're asking is that somebody would have to check the vaccination passport of a person, meaning presumably that fines could be imposed upon a church or people could be committed for an offence, or you have the optics of police entering into a church, middle of a service, after it, whatever it is, to check, in fact, that people have had their vaccine passports looked at. And I think those optics are going to be incredibly problematic if that's the state we actually get to.
Most religious congregations, as I understand them, have at the door of the church or the place of worship a volunteer, and they don't so much police entry as welcome entry. Who would actually be responsible if an unvaccinated person entered a church or the place of worship? Who would be responsible?
I think that's just a very uncertain question. Could it be the priest? Could it be, as you say, the person at the front? Could it be the parish council? Could it be the wardens of the church? That, I think, would be a matter of the internal polity of the church and how it organises their own authority. But that would be uncertain. Is there going to be a fine imposed upon these people? Or will it simply be, for example, the unvaccinated person who turns up at the church? Will they be committing a public health order offence?
The religious leaders who have written to the New South Wales government say that the service they're providing is not an entertainment, it's not a recreation, that for many people religious observance is a necessity. In a legal situation, would that bolster their case?
So again, the legality of it is difficult because there's nothing to hook on to here, I don't think. There's nothing to say you've breached something like the Bill of Rights in the United States. Our free exercise clause in the Constitution is at the Commonwealth level only. So if we're dealing with New South Wales, again, these are going to be matters of political debate, and that's why you see this negotiation going on between the religious leaders. But let's take the Archbishop of Sydney, the Catholic Archbishop of Sydney, Anthony Fisher's statement that no one should be excluded from communion. Now, what does he mean by that? He's saying that no one should be excluded from communion with God, the actual act of Eucharistic celebration, right? There, he's saying that actually that's at the heart of our religious liberty claim.
How do you think a court might look at it? Would they make the distinction between a religious service and going to see a band in a pub?
So say this did come before a court. Sometimes you see courts are a bit more open to what you could call the internal point of view, adopting an imaginative sympathy for what's going on. So they don't necessarily say, well, I'm a Catholic too, or I'm an Anglican too, and so therefore da-da-da-da-da. but they enter into what the religious group is actually saying, and so they understand the importance of what's being said. Now, that doesn't mean that the religious claim wins, as it were, because there could be competing interests that simply mean that the religious claim gives way. But in other instances, courts have actually been quite poor at this, and they show quite a lack of imaginative sympathy, to the point that they see, for example, that they must hear the religious claim purely within a secular register. And so that turns something like Archbishop Fisher's statement about communion with God into more like a generalized, I want to associate with people in a very, important way, but just generally associate with people.
Do we know how this issue of church closures or limitations on worship has been dealt with overseas in other jurisdictions?
Look, there's been multiple debates and claims around this. Lower courts in Scotland have referred to the European Convention on Human Rights and disproportionately limiting religious liberty by criminalising the meeting of churches during lockdowns. There was a lot of debate in Ireland around what some people were framing as banning the Eucharistic celebration. In the United States, there's been a lot of cases that came up during their lockdowns over whether it was unconstitutional to allow the opening of, say, shopping malls and cinemas while closing churches. And that was just a basic claim of equality. If you're going to allow the opening of some institutions, then you should allow reciprocally the opening up of religious organizations and so on, unless you could provide a rational reason for why those should be distinguished, right? But that's just a very thin claim of treating with equal treatment. Whereas what we're talking about now in the Australian context is the argument that, more like in that sort of Scottish one I said, that religious liberty is of supreme importance here, and it should be treated differently for the reason that it's pursuing a higher good, like what Archbishop Anthony Fisher said, that communion with God.
Sydney University law lecturer Joel Harrison.